We are happily gathered to acknowledge beloved Prime Creator and the magnificence of this creation. Waking up to it daily is the gift given after the night work we do as we leave our bodily awareness to eternal consciousness night after night. Back in body, our team, our social compact, chooses daily to address what we see and feel to be the evil either perpetrated or perpetuated by those who ignore. Through our relentless efforts, we know their ignoring is not out of ignorance, but is a determined effort to sustain their positions of authority. These persons wield their will and ignoring over anyone willing to subject to them. We are not subjects to their will. We do not submit, yet they sit or stand behind policies set out of fear and shielded by thick glass or plastic as the front line of the oligarch's defense team. They choose to placate us with their frontline presence, expecting that we will be good and not cross their line. Now is our task to do something different, to challenge engagement face to face, to be able to hold them to a standard we know to be right and just. Their ignoring does not mean they are ignorant. We will prevail. The next how is for us to determine now. Let it be so, and so it is.
Hello, my name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. I want to read a little script here. I wrote it out longhand. We were in a meeting the other day, our court, and I think there was 5 of us, was visiting a state of Oregon agency. And the guy looked at us and he says, "What do you want?" And we responded to him in writing what we wanted. And that brought me to the conclusion I need to do the same thing in audio form with the sheriffs, the 36 sheriffs on Oregon. What do you want? Is the question. And our response is the remedy with our sheriffs is reasonable. A proper oath to the proper constitutions with the laws of nature and nature's God included. Now, this is not something that someone signs off on, like Bill signed off for Nick on Marion County. They had an oath, and Bill registered it, that Nick had done it, and the judge signed off on it, and that is absolutely incorrect. And it was accepted and recorded, and we have a copy of it. Nothing was fulfilled in what they did. Bill doesn't get to sign off on a document just because he's the recorder. And the judge can't sign off on it because the value is more than $20. And Amendment 7 requires, in suits in common law where the value is more than $20, it has to be decided by a jury, not a judge signing off on what Bill said was okay for Nick to do. That's not an oath, guys. It really isn't. Okay. What it takes is it takes a court of 3 tribunals, a clerk, and a marshal. If you're going to do it just exactly right, that's what you need to have a county sheriff take an oath. That is legitimate. So when they hear the oath, now we're talking common law, so it's not what is written, it is what is said and heard. So you hear the oath. That's why when they make a big deal about the president, look how many people hear him take the oath. A specific oath written down in the Constitution. They knew exactly what they wanted. So if an oath is taken, it has to have 2 witnesses, just like an affidavit. It's not just what you say you said and what your buddy agrees that you said. It's the oath that's taken and at least 2 witnesses, and it has to be heard and signed, recorded, and kept. And not one of our 36 sheriffs have that. Not one. We went to Lynn County and got the records from the Lynn County recorder. Her name doesn't come to mind right now. Riley? And paid our 25 cents a copy. And for $1, we got a copy of what they have recorded in the file for the sheriff of Lynn County, Duncan Kelly Michelle. Yes, I think that's exactly right. So we got that, and it doesn't contain an oath at all, not even a bad one, not even one that's not acceptable. We have one of those also. But you have to have a proper oath to the proper constitutions, and we explained that, and here it is again. Misprision of felony. The felony is Article 7 amended was placed into the Oregon Constitution without a lawful procedure. Exactly how they got it in there, a lot of it's proven and a lot of it's a guess. Happened a long time ago, and they've been doing their best to cover up all the records. But the fraud happened, and they have been perpetrating this fraud of Article 7 amended upon all of us on Oregon for 115 years. Their law form makes it okay. In their law form, he who can be deceived, let him. So we were deceived. We're no longer deceived. Your law form is not acceptable. You have no bona fides. You cannot fulfill the office. That's what it is. Now, if you think you can, and a lot of them apparently do, we're going through the process. We can read ORS 206. We can read Oregon Constitution 1859. We can read United States of America's Constitution circa 1859. The last lawful documents that we can pretty much identify the bona fides of. We've had 115 years of lying. That's just how it goes. We can't fix that, but we can provide remedy. And remedy is we're not going to do it anymore. We're going to do it the correct way from here on because we're not deceived. We're going to rectify the mistakes. When they were first starting out this outfit, Judiciary Act of 1789, Section 32, pretty smart guys in a lot of areas, they said, if somebody is smart enough in law to see a mistake, correct it, and we'll move on. So if you see a mistake that we're making, correct it. Correct us. That's what it's all about. It's getting to original jurisdiction before the fraud. Roll it back, see the fraud, see what happened, see who did what, correct all the errors that you can. You can't correct everything. We're seeking remedy. We're not going to do it anymore. So we need a proper oath. You have to do it. Nobody can do it for you, and we can't do it alone. So there it is. We have 36 sheriffs, and we have an Article 3, Amendment 7, Civilian Common Law Court of Record. And you'll abide by the law, the constitutions, ORS 206, and the human resources requirements of your county, and we'll do it all correctly. That's all. It's not rocket science. That's what we want. Now, do we get it? Of course we do. All power is inherent to people, and they're speaking to you now through me, the old white man talking head. And I yield.
Hello. Whether it is not Whether or not those of you in Oregon governance positions got the memo, this is it. You and your positions in the bankrupt, defunct, fraudulent United States Corporation, all caps, are fired. Your oaths to that corporate, all caps, entity are null and void, just as is the Maritime Admiralty de facto law form you promised allegiance to. Cease and desist notice with a notice in demand. Notice to agent is notice to principal. Notice to principal is notice to agent. To all Oregon governance employees elected and appointed, past and present, your services are no longer needed. Our provisional de jure government, consisting of men and women on the land and soil jurisdiction, are now letting you know you are no longer in positions of authority, that your de facto jurisdiction is fraudulent, is null and void, and has no authority over the people on Oregon. Our Article 3, Amendment 7, Civilian Common Law Court of Record, has been giving you, many times, any and all of you, fair notice and demand to take heed to the prevailing law of the United States of America and her, intentional pronoun, original common law jurisdiction, wherein the laws of nature and of nature's God are the ultimate law of the land and soil. This. Ours is the only constitutional and therefore lawful de jure court on Oregon. We declare that Article 7 amended, with all its courts and attorneys, with all the judicial goings on since its insertion into our Oregon Constitution, all caps, are and have been fraudulent, therefore are a nullity not to be complied with. To all Oregon governance entities, your behind closed doors meetings in defiance of the incoming Trump administration have not gone unnoticed. Your plans to defy changes made by the incoming administration's policies are the very reason for the massive vote in his favor, votes for a more measured and conservative approach to government, one that decisively moves the needle to our original jurisdiction as a democratic Republican form of government, not a communistic, socialist, Marxist democracy. We are a republic. Your actions in defiance of a national election deny the public mandate of a determined populace that demands the reclaiming of our values as a nation. More money and more taxes on us and thrown at your policies and agendas are not working and are certain to create more problems than solutions and remedies. Those may be found at www.orsja.org. Thank you. Ex parte Milligan, 71 U.S. 4 Wall 2, 1866, was a landmark decision of the U.S. Supreme Court that ruled the application of military tribunals to citizens when civilian courts are still operating as unconstitutional. In this particular case, the court was unwilling to give President Abraham Lincoln's administration the power of military commission jurisdiction, part of the administration's controversial plan to deal with Union dissenters during the American Civil War. Justice David Davis, who delivered the majority opinion, stated that martial rule can never exist when the courts are open, and confined martial law to areas of military operations where war really prevails, and when it was a necessity to provide a substitute for a civil authority that had been overthrown. Chief Justice Salmon P. Chase and 3 associate justices filed a separate opinion concurring with the majority in the judgment, but asserted that Congress had the power to authorize a military commission, although it had not done so in Milligan's case. The landmark case stemmed from a trial by a military commission of Lambden P. Milligan, for whom the case is named, Stephen Horsey, William A. Bowles, and Andrew Humphreys, that convened at Indianapolis on October 21, 1864. The charges against the men included, among others, conspiracy against the U.S. government, offering aid and comfort to the Confederates, and inciting rebellion. On December 10, 1864, Milligan, Bowles, and Horsey were found guilty on all charges and sentenced to hang. Humphreys was found guilty and sentenced to hard labor for the remainder of the war. The sentence for Humphreys was later modified, allowing his release. President Andrew Johnson commuted the sentences for Milligan, Bowles, and Horsey to life imprisonment. On May 10, 1865, Milligan's legal counsel filed a petition in the Circuit Court of the United States for the District of Indiana at Indianapolis for a writ of habeas corpus, which called for a justification of Milligan's arrest. A similar petition was filed on behalf of Bowles and Horsey. The 2 judges who reviewed Milligan's petition disagreed about the issue of whether the U.S. Constitution prohibited civilians from being tried by a military commission and passed the case to the U.S. Supreme Court. The case was argued before the court on March 5th and March 13th, 1866. Its decision was handed down on April 3rd, 1866. Prepared by Francis Lieber, promulgated as General Orders No. 100 by President Lincoln, 24th of April, 1863. Instructions for the Government of Armies of the United States in the Field, prepared by Francis Lieber, LLD, originally issued as General Orders No. 100, Adjutant General's Office, 1863, Washington, 1898, Government Printing Office. Article 1, Section 1 of Oregon's Constitution, Natural Rights Inherent in People. We declare that all men, when they form a social compact, are equal in right, that all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness, and they have at all times a right to alter, reform, or abolish the government in such manner as they may think proper. This is taken from oregonsya.org. Article 1, Section 1 of Oregon's Constitution, Natural Rights Inherent in People. We declare that all men, when they form a social compact, are equal in right, that all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness, and they have at all times a right to alter, reform, or abolish the government. When referring to the First and Second Amendments of the United States of America's Constitution, free speech and the right to bear arms has somehow gotten twisted in the minds of the general public to be considered extreme conservatism. That very perception is the result of the intensive programming wrought on the people by those who choose politics over the United States of America's Constitution. Since when is upholding the original, the United States of America's Constitution, have been increasingly trampled? In its Bill of Rights associated with extreme conservatism. These first two amendments to the Constitution have been increasingly trampled, increment by increment. A little bit here, a little more there. So here we are, decades and generations later, oblivious to the overreach and downright ignorance of this sacred document that has kept this nation as intact as it has prevailed, despite constant onslaughts. Conspirators, all persons employed by or associated with police, sheriffs, marshals, and others of that ilk on Oregon, operating in the de facto incorporated governance of Article 7 amended, either self-correct to the de jure Article 7 original, or be tried in our de jure civilian court of record with a true bill from our grand jury. Does everyone understand?
Yes.
Returning to a de jure government after more than 100 years of deceit due to Article 7 amended is difficult, and we put forward our best effort. Article 1, Section 1, natural rights inherent in people. We declare that all men, when they form a social compact, are equal in right, that all power is inherent in the people, and all free governments are founded on their authority, and instituted for their peace, safety, and happiness, and they have at all times a right to alter, reform, or abolish the government in such manner as they may think proper. That's from the Oregon Constitution.
Article 4, Section 4. The United States, that's the de jure United States of Washington District of Columbia, not the de facto incorporated bunch that's there now, but the United States shall guarantee to every state in this union a republican form of government and shall protect them against invasion and on the application of the legislature or of the executive when the legislature cannot be convened against domestic violence. Okay? We have to be able to get there. And what took us 4.5 years to accomplish on Oregon can be done by a Jural assembly of 5 or 6 in 15 hours work, $60 for postage, $40 for a seal, file all the paper at the same time, and in 30 days it's a fact. Use your time waiting to gather your jury pool of men and women to populate your grand jury, your petite jury, your clerk of court, your marshal, and provisional government on your state, commonwealth, or territory.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. And then he jumps out of the car. And he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, just shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.